Yes, so welcome participants to another webinar of Lexist today. And today's topic, as you know, the hot topics in investment arbitration about energy, natural resources, environment issues, and also the recent trends in investment treaties. So my name is Turgut Aycan Özcan. I'm the head of the arbitration practice at Lexist. And today I'm together with very distinguished lawyers who are experienced in both investment and commercial arbitration. So our first speaker is Professor Attila Tanzi, who is the chair of international law at the University of Bologna and also associate member of 3BB chambers in London. Professor Tanzi is acting as counsel and arbitrator in various investment arbitrations, including exit and ancestral cases. He is currently a member of Permanent Court of Arbitration. Professor Tanzi also advises governments and international organizations on international law issues. He has held numerous academic positions and has published extensively in English, Spanish, French, and Italian on state responsibility, foreign investment law, environment law, the law of international organizations, and jurisdictional immunities. Today, Professor Tanzi will talk about case law developments with regard to the natural resources and the environment. Our second speaker is today Ms. Anna Gayart. Just a second. Yes. And Ms. Anna Gayart Sasko, who is the associate in the international arbitration practice of Sherman and Sterling in Paris. She has experiences in international arbitration under the ICSID, Ancestral, ACC, and ICC rules, with a particular focus on Ukraine and the CIS region. Notable international arbitrations on which she has worked include state representation, including Ukraine, and also Ukrainian State Road Agency in set-aside proceedings before the Paris Court of Appeal. Ms. Sasko is admitted to the practice law in Ukraine and France and speaks English, French, Russian, and Ukrainian. She is recognized as a future leader in international arbitration by Whoisu Legal. So today, Ms. Sasko will talk about recent trends in international investment treaties. In fact, we would have another speaker, Mr. Antolin Fernandez Antuna, but unfortunately, due to some personal reasons, he couldn't attend this webinar, but we hope to organize another webinar with him as well in the near future. And finally, I will make a brief speech about the possibility of establishment of an international arbitration court for energy disputes. And then we expect to get some questions from the participants to answer these questions. So right now, I would like to give the floor to Professor Tanzi.
Well, thank you very much. Well, first mistake I'm going to make is the pronunciation of your name. I would tend to say Aycan, but I understand it should be Aycan or something like that. Aycan.
That's right, Aycan.
Aycan. Well, thank you very much for the invitation, for putting together this this event, and there's also this opportunity to exchange views also with colleagues in practice like Anna, and to interact with the young and able lawyers who have enrolled in this enterprise. Well, I may be unsatisfactory as far as perhaps getting into the niceties, the nitty-gritty of certain issues for those who are particularly curious and would like to get deep into the details of our discussion today, because I am sitting currently in arbitration, where the arguments we are topics, side topics, subtopics we are discussing today are probably relevant to cases in which I'm sitting as an arbitrator, and I cannot possibly make strong statements that could predicate my attitude in the decision-making adjudicative process. So I ask you to bear with me on that. Thank you very much, Ajahn. And the other thing that I have to say is that if I'm going to focus on jurisprudential developments pertaining to disputes revolving around natural resources, the protection of environment, public interest concerns, and at large, as we all know, as a very basic fact, arbitrators apply the law, and the applicable law here is primarily in international investment agreements. And Anna is going to speak about those. And there is an interesting development there, which means development in the field of the applicable law by arbitrators. So everything that I'm going to say is going to be said as far as I possibly can with regard to the jurisprudential attitude by arbitrators, but you always want to take into consideration that the arbitral decision-making process is dependent very much on the applicable law, and arbitrators are to keep within the boundaries and confines of the applicable law. But interestingly, I'm going to make some remarks about attitudes in interpreting the same or similar applicable law frameworks. Before getting into the jurisprudential developments, and next to the jurisprudential developments, I'm also going to refer to some developments taking place in international institutions which pertain to procedural law, which is relevant to the entertainment of environment and natural resources related issues falling within public interest concerns, namely possibility for defendant states to lodge counterclaims or issues of transparency. Before that, I'm also going to make few general remarks about the topic that we are addressing, which is probably tying in an anticipated way with proposals coming from Ajahn in due course. But let me stick to some degree of taxonomy, classification. Is there anything so very special within the field of arbitrable disputes under the investor-state framework with regard to natural resources and the environment? Well, there are some specificities, certainly, and there are major overlaps. There are certainly a specific part of the investor-state arbitration at large, but disputes about environment, natural resources partake of the general and traditional tension that we find in international investment arbitration, as it was originally put in place and is still in place, God willing, between the private interests of the investors and the public interests of the host states. Now, the practice and case law concerning private investment in, say, oil extraction, mining, hydropower, or other energy production or distribution activities and the like, may find themselves in circumstances where investors may advance the usual traditional claims against the host states when they find that host states have incurred breaches of the classical pillars of international investment law. Prohibition of expropriation, either direct or indirect expropriation, breach of fair and equitable treatment, or breaches of full protection and security. Now, let me refer to the hydropower sector as particularly exemplary for our purposes. We are in the field of energy production, but we are also in the field of activity which may impinge significantly on natural resources. Say, when you put up dams, they certainly have an impact on geology, and not just that, also on economic and social factors of the region where they are going to be. And certainly Turkey knows about it, with the great Anatolic project, to mention one. Now, while hydroelectric power stations account for about 20% of the world's electric energy, the international law framework relevant to foreign investment in this sector largely applies, as I anticipated, very much on a par with foreign investment in the energy industry in general, and maybe not just energy industry. You have hydroelectric energy investment partaking of the general division of the energy economic process in general into three sections, which may, according to each particular investment, as the case may be, electricity generation, transmission and distribution, financial, economic investment, civil engineering investment. You have financial and economic, infrastructural, social cost, benefits, considerations that provide the basic context for an arbitration, dispute, analysis in any given hydropower investment. And what allows me to be speaking to you today is, in general terms, is that indeed every individual case is factual and legal specific. But now, energy and natural resources kind of disputes have their specificities, but they fall within certain general frameworks. Now, against this background, public authorities of host states may take measures having important bearing on private investment in this field. Such investment is often of a foreign nature. They may take measures which involve incentives, or they may take measures that make the foreign investor's life almost impossible, keeping on asking to fulfill more and more requirements. Sometimes once the investment has been put in place, regulatory requirements may change and the bar may be lifted. Such infrastructure investments indeed may involve serious risks of involving adverse impact on the social, economic, and natural resources scenery of the country where they invest. In other words, the hydrological nature of the generation process combines the actual building of the power plant with the construction of a dam, more often than not, which may have different environmental and social impacts. Different kinds of investments and investors, different investors, which may be, who may be foreigners, may be involved in the process. construction, finance, different legal relationships, different public contracts. So out of one energy project, you may have different kinds of legal relationships and different possible kinds of disputes that may be eventually brought before an investment arbitration tribunal. This was to focus on the kind of investment and the kind of investors that you may come across with in investor arbitration, investor-state arbitration. But let's look at the position of states. Whereas investors may lodge the usual claims about expropriation, breach of prohibition of expropriation, breach of fair and equitable treatment, or breach of protection and security. On the other hand, states may raise the usual defenses, ranging from the pursuit of the general interest, proportionality, police powers, or some modulation in some form and shape of the regular freedom to coup. Already taking from the examples that I just made, there are certain activities which are more susceptible than others to fall within the scope of environmental concerns by host states. That is certainly the case with regard to the energy sector, but in the rest of investment public utilities, you also have no less cases that may be easily brought before investor-state arbitration tribunals in activities such as mining and extraction, oil, natural gas, where environmental protection ties in with other areas or processes of international law. As we'll see in a minute, you have certainly a human rights body of international law, which may come into the picture, and environmental law as a separate branch of international law, which is one of the examples of the ongoing debate about the alleged fragmentation of international law. You have different branches of international law, and the big issue is how to integrate their interpretation and application. There are tools that we are going to address in a minute. But there is one particular international law discourse, which is not a body of law in itself, which we want to keep in the back of our mind when considering these kinds of issues, which may seem a little bit dépassé, but it's the debate that started in the 1960s and 70s around the so-called permanent sovereignty over natural resources, which inspired claim for the emergence and consolidation of a new international economic order. That was a legal policy discourse that gave a big blow to the then established body of international law concerning the treatment of aliens. That body of international law from which international investment law has found its origin. After the end of the Cold War, this new reinterpretation of the treatment of the law on the treatment of aliens has gathered force and universal recognition through its incorporation into international investment law, with the new dispute settlement system through arbitration, where private investors could sue states based on the generalization of shared acceptance of the liberal conception of the economy, organization of the economy domestically and globally, and therefore the new international economic order appeared defunct. Well, now, I dare say that much of the ongoing debate over the reform of the international investment law system is reminiscent of the new international economic order. So I would very much advise you, in order to see the roots, the ideological roots, look at that discourse, which is back with new clothes. Now, going back to those activities so intertwined with environmental protection and the regulatory framework, both domestic and international, which is applicable to that, foreign investors' due diligence requirements become ever more sophisticated. And they are becoming ever more relevant in order for arbitrators to uphold the investors' legitimate expectations concerning protection, let alone respect of their investment. Due diligence may be increasingly becoming relevant for investors, not only from the applicant's perspective, but also as potential defendants with respect to counterclaims. Claimant investors may find themselves as defendant with respect to counterclaims being advanced by origin in the principal claim host states defendants. And this is becoming more the case, I mean, with tepid increase in statistical increase, but particularly with regard to disputes which bear on environmental and natural resources issues. Now, it may be taken for granted that by introducing environmental concerns and regulation into investment arbitration, the investor's position is legally weakened than that of host states. Actually, you would assume that while the investor's position is weakened, that of host states is enhanced. Now, there is no denying that this is true in many respects, also at the level of domestic law, as a matter of fact. But at the same time, one should not lose sight of the fact that under the general principle of the rule of law and legal fairness, the increasing international regulation on the environment is increasingly putting a significant due diligence regulatory burden on host states, one which maybe have to be taken into account on a case-by-case basis in investor-state arbitration context. Indeed, the lack of fulfillment of such a due diligence burden by a host state may be vindicated by foreign investors, as the case may be, either in their position as applicant, and I may recall in Bilcon versus Canada, and in Allard versus Barbados, but also in order to defend themselves with respect to counterclaims by states, whereby the basic principle of good faith, whereby you cannot defend a position when you don't have clean hands, and this applies generally to, is deemed to apply generally to claims lodged by investors. Actually, the same would apply to host states when they act as claimant in a counterclaim context. Environmental protection purposes unquestionably expand the scope of some kind of regulatory prerogatives by host states. When international stringent due diligence standards are complied with by the investor. However, environmental protection may not necessarily provide license for unfettered expropriation by host states. Among the many cases that may come to mind, one may recall the Metaclad case between a United States company and Mexico, where disposal waste project, the landfill, involving quite a significant investment by the US investor, was being authorized by the federal authorities of Mexico, and then the investment was realized, and after a number of long months with considerable investment, the local authorities sided with protest by local populations. The inauguration of the landfill resulted in major social unrest, and reiterated ever-increasing local regulation requirements were being asked of the foreign company, new permits, which were not provided for when the investment got started, and then the area where the landfill had been constructed has been turned by the local authorities into a natural park. Now, the construction of a natural park can very well be said to be a measure that is environment friendly, actually promotes the protection of the environment. But obviously, this would be a case of abuse of environmental considerations in adopting measures that may curb the right of the investor. From a conceptual general principles pertaining to the interpretation and application of the law, without prejudice to what Anna is going to tell us about any specific positive black letter language that you may find in each applicable international investment agreement, the big issue is what to do with international regulation on the protection of the environment for the purposes of the interpretation and application of law envisaged to regulate the economic relationship between a foreign investor and a host state at the time when environmental concerns did not exist, or even when some references being made to public interest measures or measures aimed at the protection of public interest. And the big issue is whether the body of international investment law could be somewhat, and how could it be somewhat taken into account in investment law and in investment law disputes. Now, a colleague and a practitioner, a colleague of mine, a practitioner, Professor Jorge Vinuales, who has quite some experience in investor-state arbitration, has advocated for the legal reasoning to be adopted by investor-state arbitrators that has been carried out by the International Court of Justice in a famous case between Slovakia and Hungary. There was indeed an issue of environmental concerns. There was an issue of energy. You had the two countries entering into a bilateral agreement, which was mainly an infrastructural kind and energy-focused treaty in 1977, and in the mid-80s, in the early 80s, Hungary said there is environmental considerations to be taken into account when realizing this treaty. I'm first suspending the realization of the execution of the treaty, and then I am terminating it because it runs counter to the basic pillars of international environmental law. So the big question was about whether there was a legitimate ground for termination of the treaty, which was of an exclusively energy and infrastructural dimension. There was no reference to environmental concerns. And there the court made some reasoning to the effect that it incorporated by reference international environmental law into the law which was to be taken into consideration when applying economic focused piece of treaty. You may assume, for those who don't know this case, that then the court, by having incorporated by reference environmental law into the economic treaty and infrastructural treaty, basically it found for Hungary. In fact, that was not the case, but the statement is pretty strong. And the mechanism that was suggested by Professor Vinoales to be copied and pasted to reasoning in investor-state arbitration could be quite significant. Let me just anticipate that this is not yet very much the case, even if the tool for some kind of mild incorporation of branches of international law which have a legal life of their own outside the system of investment law can be found in Article 31(3)(c) of the Vienna Convention on the Law of Treaties. And as Anna will confirm, you are to interpret and apply investment law treaties according to the general customary rules on the interpretation of treaty law, including investment law treaties. Now, I'm going to cut it short for the time being, and before I do that and leave the rest of my presentation for consideration in answering some of your questions, but let me give you an example outside environmental law, but which would operate and still operates very much in the field of environmental law or related disputes. Since we are in Istanbul, I wanted to pick from a case which involved Turkey. It's an old case in which the issue of Article 31(3)(c) came into the picture in the reasoning of the tribunal. That is the Tulip Case that probably some of you remember. It arose out of the interpretation and application of the Dutch-Turkish BIT. Turkey terminated a mixed use of residential real estate development project in Istanbul. And the tribunal found for Turkey, holding that the conduct by complained of were not attributable to Turkey, and in any case that they would not constitute breaches of the BIT. The investor sought annulment, as you have annulment proceedings under Article 52 of the ICSID Convention, and the claimant argued that the tribunal had breached its right to a fair trial in the treatment, with special regard to the oral proceedings. And the principle of fair trial is codified in human rights instruments. Well, I don't think you needed really to go outside the scope of investment, the applicable investment law, because you would expect that fair trial is part of fair and equitable treatment, let alone full protection and security. But be that as it may, it's interesting that the annulment committee refer to Article 31(3)(c) of the Vienna Convention, saying it directs that, and it quotes the treaty, any relevant, the interpretation of treaty is to take into consideration any relevant rules of international law applicable in the relations between the parties. The relevant rules of international law cover all sources of international law. The only requirements of Article 31(3)(c) are that the rules are relevant, and that the rules are to be relevant, and that they are applicable as between the states parties to the treaty to be interpreted. Provisions in human rights instruments dealing with the right to a fair trial and any judicial practice thereto are relevant to the interpretation of the concept of a fundamental rule of procedure, as used in Article 52 of the ICSID Convention. This is not to add obligations extraneous to the ICSID Convention. Rather, resort to authorities stemming from the field of human rights for this purpose is a legitimate method of treaty interpretation, end of quotation. So here, and I will probably in the course of the discussion have the opportunity to see how this Article 31.3c has been used in reasoning by investor-state arbitrators with regard to environmental related disputes, is something that is often used by way of obiter dicta reasoning, which could also apply to ratio decidendi, but at the end of the day, it is not being consistently applied, and there is by investor-state arbitrators. There is a fair degree of oscillation in the incorporation of let's say, environment-related legal values. And I dare say, without prejudice to what Anna is going to say in a minute, also where the case is being governed by an investment agreement where reference is being made to the right power of the host states to regulate issues of public interest related to the environment. I will stop there and keep the rest of my presentation to be used in the answer to questions. Aycan, if that is fine.
Thank you very much, Professor Tanzi. Thank you very much for this very enlightening and very comprehensive speech. And also, this was also very useful for all of us because you already started from the first roots of the concept, beginning from the new international economic order, permanent sovereign rights of the states over the natural resources, and of course the effect of the Vienna Convention, especially Article 31 to 33, and the implementation or implications of these provisions on the natural resources issues in investment arbitration. Thanks for this very useful speech. So right now I will give the floor to Anna Gayart-Sasko for her speech.
Thank you, Aycan. Good afternoon, everybody. Thank you for having me here today. I would like to thank also Aycan for organizing this webinar and giving me opportunity to discuss the hot topics in investment arbitration. Today, I will start with a discussion of general trends and moods in the investment arbitration, and then I will address some examples of the recent treaty drafting. In general, investment arbitration have expanded to an unprecedented level our days. Where there were around 400 treaties in the late 80s, now there are more than 3,000 bilateral, sectoral, multilateral, regional agreements today. Also, we see that a new case is being initiated, if not every day, almost every week. And in these circumstances, it comes with no surprise that the system was criticized. As the system is criticized not only by the state and investors, but also by general audience and the press. Starting from early 2000s, some reputable sources such as The Economist, the Financial Times, the New York Times have been publishing articles criticizing the system, and it started with criticizing the NAFTA arbitrations, saying that arbitration is a private circle open to a very limited number of arbitrators, potential arbitrators, that the deliberation is taking place secretly, that not all the decisions are public, and the system lacked transparency. And another criticism was that as a result of this decision, it led the government to repeal national laws, doubt about the legal system, judicial system, and environmental challenges. And we see how even today, so it started in 2000s, but even today we see that the press sometimes is very hostile towards arbitration and criticizing not what just I said, but also the cost, and that once it's somebody violates on the part of the government, on the side of the government, but then it's ours, the taxpayers, paying back to the investors. So the first wave of the negative reaction resulted also in a number of countries renouncing the exit and BAT. It started and terminating different BATs. It started with the Latin American states. It was for Bolivia in 2007, Ecuador 2009, and Venezuela in 2012. So they were, these countries were criticizing, but other countries as well, that in general, the arbitral tribunals are given very wide competence, and that while dealing with very complex and delicate issues that concern host countries' regulatory power and the host party rights to regulate, they become themselves regulators, and they can take decisions, and they take decisions that influence the regulation power of the state, and it diminishes states' right to regulate and to promote human rights, protect environment, improve public health. So that just the arbitral tribunals became regulating tribunals who are regulating public policy for the states. Another criticism was that the arbitration system, investment arbitration system, is one-sided. As the investors have a lot of rights, a lot of different protections, but there is no corresponding responsibility for them to comply with obligations, or to just, it's like one side road. Another criticism was also that the arbitration decisions and the system lack transparency and predictability, because as we know, it happened already many times when different tribunals interpreted similar provisions. They were interpreted in different ways, so it was now it's difficult to predict, and that's why it's also there are a lot of discussions of whom to appoint as arbitrator, and while selecting an arbitrator, we lawyers read all his articles, publications, and now I think it will be even more difficult because we will need to watch all the webinars. There are a lot of webinars to watch. So what states in this criticism? So we have all these different reforms by different institutions. We have reform of the Uncital group, UNCTAD, providing the different useful tools. We have also the reform of the Energy Charter Treaty, and at the same time, the states also took this opportunity, took this time to think about what can be done to protect their interest and the interest of the people. And also, as many old generation treaties were coming to the end, so it was also a good timing to renegotiate or conclude new treaties. And in these treaties, in new generation treaties, the states emphasize not only the importance of protection of investors, but also importance of government objectives. Also, they reframe and clarify the scope of protection by including more detail and precise wording for different standards of protection. And also, they impose obligations on the investors, such as a classic obligation to comply with the law for state, but also some provisions on corporate responsibility and protection of and the respect of other provisions. And it's very important that this system is this changes is taking time now, because even like in 2018, 2019. The prevailing majority of the cases were initiated on the basis of old BATs, BATs of old generation. So it just, for example, in 2018, 60% of the cases were initiated on the basis of the BATs that were concluded in the 90s or even earlier. And for state, it's now time to, so many states took time and reconsidered their policy in BATs. States adopt new model BATs, for example, as Turkey. And in this new BATs, they reflected, majority of these BATs reflect different criticism, different discussions. When it comes to definition of investment, so we know that investment usually it's what have been discussed for years, that it's not just the asset, the property, but it also should involve certain duration, contributes to the sustainable development of host state, and involves the commitment of capital and assuming some risk. So now the majority of new BATs include this new requirement of sustainable development. And even they provide how we can define this contribution to the development of host state. This example are increased production capacity, economic growth, quality of jobs created, duration of the investment, and technology transfer. So these are not exhaustive examples, but then can serve as an example for the tribunals while deliberating on the different issues. Also, in the new Generation Treaties, the states decided to include list of assets that they don't consider to be an investment. For example, this can be portfolio investments, debt issued by a party or loans granted to a party, any order or judgment entered in a judicial or administrative action, intellectual property rights which are not protected under domestic law, market share, market access, or similar intangibles, and also very interesting costs incurred before the establishment of the investment, including costs for licenses, permissions, and permits. And as we know that it's very often in different countries that the investor fails at the state, not the investor, the investment fails at the beginning, even the change through the tender proceeding or something goes wrong. So all the money invested and efforts investment before the project has come to life are not protected. Also, there were some developments with the definition of the investor. We know that the states are horrified by the mailbox companies, by treaty shopping. So there is a new requirement. It's not enough to be constituted or organized in accordance with the law of a state, but now in order to be a qualified investor, this company has to conduct substantial business activity in this state. Another provision that Professor Danzi already mentioned that caused some problems interpretation of this provision is fair and equitable treatment. It's one of the most litigated provisions, and in around of 80 cases, this provision is being mentioned by the investors, and very often the tribunals renders decision in favor of the investors for violation of this provision. So this provision is very controversial because it's very often very broadly worded, and it was difficult for the tribunal to interpret in the same way. And now the states took the initiative to clarify the meaning and specify the scope. And even in some new BATs, there is no more word fair equitable treatment, or even this standard of protection is omitted. But just the BATs just provide a list of obligations that can be considered as a violation. So denial of justice in criminal, civil, or administrative proceedings, fundamental breach of due process, manifestly arbitrary conduct, targeted discrimination, for example, on the ground of gender, race, or religious beliefs, or abusive treatment such as duress or harassment. So it will be very interesting to see how the tribunals will interpret these new provisions. Another very disputed provision is non-discrimination provision that include national treatment and the most favored nation treatment. And what was also discussed a lot, what does it mean in the like circumstances? And it also took a lot of paper to discuss what it means. And in the new generation of treaties, the state took this opportunity to provide and to clarify also what is in like circumstances mean, and especially in which situation it's not applicable. For example, when the state decides to develop any domestic industry and it becomes a priority for a state, so some VATs contain these exceptions when like circumstances are not applicable in this industry. Another standard is expropriation. It's also a very controversial standard with discussion of whether it should be indirect or only direct expropriation. And now the new generation of treaties contain the same provisions that nationalization is permitted while respecting three requirements is that if it's conducted in the public interest, following due process of law, in only discriminatory manner, or against compensation. But some states also added some exceptions that, for example, if this measure is adopted in good faith by the state to protect its legitimate public interest, such as public health, environment, labor rights, it shouldn't be considered as an expropriation. And also even some treaties now exclude indirect expropriation. What is important, what was added to the new treaties is obligations and responsibilities for the investors. And first, it's as an example that while investing, the investors has to comply with international obligations of the host state, but also to conduct all the investment activity in accordance with the national law. And what is also was very discussed in recent times, not to commit corruption, money laundering, financing terrorism, and that in this cases investors would be deprived of the protection. And one of the things that I mentioned earlier is that the importance for the state to protect its public interest and also to provide more public policy exceptions. And this, as an example, just a couple of examples of these exceptions, it's necessary to protect public morals or to maintain public order, necessary to protect human, animal, plant life or health, necessary to secure compliance with the laws and regulation which are not consistent with VAT, so to prevent the deceptive or fraudulent practice, protection of the privacy of individuals, safety, imposed for the protection of national treasures of artistic, historic, or archaeological value. So just that's what I wanted to say. And if I'm looking for the questions, but I'm very excited to see how it will continue to develop further and how the tribunals will interpret these new provisions. Your microphone is.
Yeah. Thank you very much, Anna. This was a very useful beautiful and enlightening speech. And I also believe that these recent, amendments in the investment treaties, without doubt, also have some impacts and reflections in the energy arbitrations as well. So right now, I will also make a brief speech about the possibility of establishment of a specific unified international arbitration court for energy disputes. So while you were talking about the amendments in the bilateral investment treaties, in my speech also I will discuss the possibility of a new multilateral treaty for establishing such a single arbitration court for energy disputes. So thanks again for this speech, Anna. So when it comes to the possibility of establishment of a specific international arbitration court for settlement of the commercial and investment disputes arising from the energy projects, I can say that day by day, the concepts of energy and arbitration are becoming more related to each other. And therefore, although the developments until today are very helpful and very promising to solve the energy disputes through the international arbitration forums, due to the reasons that I will mention within a few minutes, there may be still a need to establish a specific international arbitration court for energy disputes to meet the needs of this industry. As you know, most of the energy projects require the involvement of several countries and multinational energy companies, and the construction of natural gas pipelines, for instance, or the construction of nuclear power plants can be given as an example for these cross-border energy-related construction projects. One of the most important natural gas pipeline projects can be the Turk Stream, which connects the Russian gas reserves to Turkey and also providing reliable energy to the South and Southeastern Europe. Similarly, nuclear power plants projects in Turkey, for instance, a power plant project in Mersin, Akkuyu, can be given as an important project, which also includes both the country side and also a Russian multinational energy company. So this shows us that most of the energy projects should contain both countries and multinational companies, and this may let us to see a dispute if happens in terms of international level, which should be resolved through the international arbitration. In addition to the various types of energy projects, it is also important to talk about the nature of the energy arbitration, which differs due to the characteristics of the dispute. For instance, if this is a dispute which directly arose between the host state and an energy company which has made investment in that host country, then we shall talk about an energy investment arbitration. However, if the dispute is just about a pure revision of the long-term gas price or supply of gas or petroleum between private or state companies, then we will talk about the commercial arbitration to solve this dispute. Apart from the gas supply or price review disputes, many other disputes related to energy activity can be also subject to commercial arbitration, such as transportation of petroleum or other hydrocarbon sources or liquefied natural gas. As I mentioned previously, energy disputes can also be subject to investment arbitration. This is generally the case where a foreign company has invested in another country in relation to an energy project. So here, the concept of and scope of the investment play an important role to determine whether the dispute in question can be subject to an investment arbitration or not. So in this regard, and with the purpose of protection of the energy investments around the world, the well-known multilateral treaty, the Energy Charter Treaty, has been signed in 1994 and came into force in 1998. So the Energy Charter Treaty was actually designed to promote energy security through the operation of more open and competitive energy markets, while respecting the principles of sustainable development and sovereignty over the energy resources. So one of the most important functions of the ECT to enable the investors having energy investments in the ECT member states to file an international arbitration case against the host state in question. So as per Article 26 of the ECT, we see that an investor having energy investment in one host country may apply to arbitration, may bring the dispute with this host state to International Center for Settlement of Disputes, ICSID arbitration, either under the ICSID Convention or the ICSID Additional Facility Rules, or a sole arbitrator or ad hoc arbitral tribunal established under the ancestral arbitration rules, and also the arbitration under the Stockholm Chamber of Commerce. So recently, we see that there are lots of arbitration cases filed against the states before ICSID based on the ECT. And one of the most famous case, as you know, is the case filed against Russia by UCOS shareholders, in which case the arbitral tribunal has ordered Russia to pay approximately 50 billion US dollar, which is the highest compensation amount rendered by an arbitral tribunal in an investment arbitration history. And besides, with respect to the disputes arising from renewable energy projects, also we see that many arbitration cases were filed by the foreign investors based on the Energy Charter Treaty against some countries like Spain, Czech Republic, and Italy because of their legislative amendments on the incentive regimes applicable to the renewable energy sources such as wind or solar energy. So on the other hand, several international arbitration centers were also established to handle these disputes, be it investment or commercial disputes arising from the energy projects or energy-related activities, which provide specific arbitration services to meet the needs of the energy disputes. For instance, the International Center for Energy Arbitration, ICEA, was established in 2013 as a joint venture between the Scottish Arbitration Centre and the Centre for Energy, Petroleum, Mineral Law and Policy at the University of Dundee. Its mission is to render qualified services in the dispute resolution arising from the energy projects. Another example is the World Intellectual Property Organization, WIPO, Alternative Dispute Resolution for Energy. Although WIPO was mainly established with the aim of preservation and protection of the intellectual property rights and resolution of the disputes arising from the intellectual property, nowadays the energy-related projects are developed, and together with the intellectual property rights, WIPO also offers alternative dispute resolution services for specific sectors such as energy. Finally, I would like to give an example from Turkey. Energy Disputes Arbitration Center, İDAK, is the first international arbitration center established in Ankara with the purpose of solving the energy disputes between companies located in the Central Asia, Europe, Balkans, Middle East, and Africa regions. So there is no doubt that these energy arbitration centers are playing and will play for a long time a crucial role for resolution of the energy disputes through arbitration. On the other hand, since the energy sector is rapidly developing, it is a reality that at one point we will come across with a high number of complicated and cross-border energy disputes, which may force us to find a pathway, a unified pathway to resolve these energy disputes. Therefore, I believe that there will be a need for unification of the current international arbitration mechanisms for energy disputes, since the different arbitration procedures subject to different procedural and substantial rules may result in problems concerning especially the enforcement of the arbitral awards in local jurisdictions. For instance, while a final award rendered in an exit arbitration can be enforced in a jurisdiction which is member to the exit convention as if it were a local judgment without need for a further enforcement and recognition process. However, if we are talking about a final award rendered under the ancestral rules or Stockholm Chamber of Commerce, then there should be a further enforcement and recognition process in accordance with the New York Convention on the recognition and enforcement of the arbitral awards. So, in order to effectively solve the energy disputes and to get effective results, there can be a mechanism, unified mechanism, under a unified international court of arbitration for energy disputes. Therefore, while accepting the valuable experiences of arbitration institutions such as ICSID, LCIA, ICC, or Stockholm Chamber of Commerce, or appreciating the existence of specific energy arbitration centers such as ICEA, WIPO, or EDAC, I'm of the opinion that the countries and the arbitration world may start to consider the possibility of establishment of a single international arbitration court for energy disputes, let it commercial dispute or investment, which may have jurisdiction to hear all commercial and energy and investment energy disputes with most suitable procedural and substantial rules. So, moreover, through the establishment of the International Arbitration Court for energy dispute, it can also be possible to create an enforcement mechanism under similar to Article 54 of the Exit Convention for direct enforcement of the arbitral awards issued by this International Arbitration Court for energy disputes without need for a further enforcement or recognition process. So, in terms of the legal structure of these International Arbitration Court for energy disputes, the Court of Arbitration for Sports can be given as an example, because as you know, CAS also was established in 1984 with the aim of resolution of all disputes arising from sports. Of course, first of all, there should be an international consensus between the states to establish such an international arbitration court, especially the consensus of the developed and developing countries, which are playing active role in the energy disputes or energy sector, would be very significant. For instance, the United Nations, on the other hand, may deliberate the process of establishment of arbitration court for energy disputes with its member states, and subsequently a multilateral treaty prescribing the authority and the duties of this arbitration court can be drafted by the members of the UN, member states of the UN. And finally, I would like to add that it is also important that since there are already arbitration mechanisms prescribed under the ECT for energy disputes, upon the conclusion of the multilateral treaty, if it became possible for the International Court for Energy Disputes, then the necessary amendments should also be reflected into the ECT to give full authority and jurisdiction to this new arbitration court for energy disputes. So this is the end of my speech. And I hope all these explanations, speeches, first from Professor Tanzi and then from Anna and then from me, would be useful for the participants. At the same time, right now, I'm looking at the questions, if there's any, to share with our distinguished speakers. So here, there is this question. So I think this question, let me ask the question first, and then I will give the floor to Tanzi, Professor Tanzi, and to Anna. Do you think that provisions referring to states' right to adopt measures pursuing public objectives, for instance, EU-Vietnam FTA, establishes a presumption for the state on the nature of a given measures? So this is a question which asked to us. So I guess this is more related to the issues of Professor Tanzi. So please, Professor Tanzi, you can just give an answer to this question.
Well, I don't know whether it is addressed primarily to me, because basically it's a matter of interpretation of language contained in an investment protection agreement between the European Union and Vietnam. So I'm pleased to join Anna in giving a reply which may not be as exhaustive as it could be, and probably Anna will give a more exhaustive answer for the reasons that I explained in the opening. I really have a bit of tied hands here, whether this treaty would give a presumption to the defendant state that it may unilaterally interpret whether its measures are, I mean, it has a free hand by the treaty. Is that the question, Aijan?
Let me ask the question again. Do you think that
the last part of the question?
Last part. So, do you think that provisions referring to the state's right to adopt measures pursuing public objectives, for instance, Article 8.1 of the EU-Vietnam FTA, establishes a presumption for the state on the nature of a given measures?
Well, a presumption of legitimacy, I suppose, of legality. That is the question. Does it? Well, I think that if there is a dispute, it will be precisely a dispute about whether that measure is justifiable under that treaty. And basically, as I personally see it, I'm curious to hear Anna's view. This would be a typical disputed issue for a third party to decide. And as I would like to say, in complement to what Anna may wish to say, is that reference to, let's say, even the regulatory freedom of states within the field of the protection of the environment is no silver bullet, is no license for states to do whatever or to take whatever measures they wish to take. There is a degree of constraint which falls within the general framework. Otherwise, let's say that it would be, let's suppose that they had states would have rights to regulate, and I think they do have, and probably they even had a right to regulate irrespective of explicit mention to the protection of environment, insofar as measures adopted in the pursuit of public interest. But as we know, it is a general principle that the holder of a right is not supposed to abuse its rights, you see. So let me take, and then I will stop, and I'll be very happy to pass the floor on to you, Aijan, and you will pass it on to Anna, I suppose. There are two interesting cases that I always like to compare, because there are two cases in which environmental concerns came into discussion, and both cases were equally against the same state, Costa Rica. So there was an interesting passage about the little relevance that the arbitrators gave to environmental concerns. So the first case is Santa Elena against Costa Rica, around the year 2000 to 2001 or something like that, I think. Yeah. And it says, let me read it. I suppose those who are not expert and don't know this case will like to hear, because it's very clear. It said, expropriatory environmental measures, no matter how laudable and beneficial to society as a whole are, similar to any other expropriatory measures that a state may take in order to implement its policies, where property is expropriated, even for environmental purposes, whether domestic or international, the state's obligation to pay compensation remains. So here you have a tribunal that finds for the applicant, setting aside the relevance whatsoever of environmental considerations. Almost 15 years later, in a case where environmental concerns came into discussion again, there the applicable treaty, which was a treaty pertaining to the CAFTA, Dominican Republic and Central American Free Trade Agreement, refers to protection, the right of states to adopt measures in order to protect the environment. And that, I suppose, is very much of a welcome development. But in the dispute, still you have issues of fair and equitable treatment, unlawful expropriation. And the tribunal does take environmental considerations into account because it has to apply a treaty which provides for such. It's Article 17, paragraph 2. And let me quote, although the respondent, I mean the host state, argues that when the article that provides for that regulatory freedom focused on the protection of the environment establishes discretionary powers to the treaty member party with respect to investigatory, prosecutorial, regulatory, and compliance for enforcement of environmental matters, this implies a manner of ensuring that a party can, as it sees fit, this is the unilateral presumption or the presumption of unilateral assessment of its regulatory freedom, implement, so a party can, as it sees fit, implement its own environmental laws without fear of violating the treaty. This is the argument that was put forward by the state, you see. Well, despite this argument, I mean, the tribunal believes that this is not an absolute right that may be exercised in any manner that the respondent desires. So you have the right to regulate in order to protect your environment. You may investigate whether investors did anything tricky. In many domestic legislation, you also have criminal responsibility, and not just of individuals. Now, the European Union, for example, has developed the concept of sort of quasi-criminal liability of corporations for environmental wrongs. Well, that being said, what the arbitral tribunal said is that, well, you may take those measures, but such measures are to be adopted within the framework of legality anyhow. So this the presumption of unilateral assessment, whether measures are proportionate, for example, and there again, the proportionality test perhaps would apply. Of course, and I'm saying that in very general terms, John, as you know, it depends on case-specific circumstances. I hope this satisfies the question.
Thank you very much, Professor Tanzi. This was very, very helpful. I mean, the presumption, as you mentioned, of the state to has, regulatory right to give some measures or to implement some measures should be limited, especially the tribunals indicate this in that way. I will just give the word to Anna before adding a few comments to the example given by Professor Tanzi. So I believe that in order to avoid the confusion, and also in order to make it easy for the tribunals to give a decision on this issue about the responsibility or liability of the states to pay compensation due to the measures with respect to the environment protection. In some bilateral investment treaties, there are specific provisions which clearly state that in these cases, there will be no violation of the bilateral investment treaty. For instance, in Azerbaijan-Turkey bilateral investment, there is a provision. I don't remember the exact article, but I will check it again. It says that in some cases, like public security or protection of natural resources, any action taken by the state cannot be considered as a violation of this bilateral investment treaty. So if there is a specific and clear provision like that, then the tribunal may have some room to interpret this. Otherwise, it can be more complicated to balance the rights of the states and the foreign investors. So, Anna, would you like to add something?
I agree with Professor Tanzi. I agree what you just said. But just in general, I think that for the many years, state felt like oppressed by this pressure to comply with, to respect investors' rights. So now states try to build regime in which they will have enough legal ground to protect their interests, to protect their rights. And it's not, as Professor Tanzi mentioned, it's not an absolute right. And we need to look at the specific wording of specific BAT, but in general, it will be up to the tribunal to interpret and to decide what was, if it was proportionate, it was arbitrary or not. And it's always up to the tribunal at the end, but then there are some exceptions. But the states, they have right to regulate, they have right to protect the natural resources. And I think that maybe there is a general presumption that states are evil and investors are just good investors trying to do some business and state just don't let them, because we have different investors, we have different states, and not always investors are acting in good faith. So I think that for me, I don't think that this is a presumption.
Yes. Thank you very much, Anna, for this answer. So right now I'm checking whether if there is any other question to us. Yes. For the time being, I don't see any other question. And right now it is already about 1.5 hours for our webinar. So once again, I would like to thank to you, Professor Tanzi, and to you, Anna, for your participation, valuable contribution, and for these very important and useful information. And I hope that all of the participants benefited from this webinar. And once again, on behalf of myself and on behalf of Lexist, I would like to thank to you and hope to see you again in the near future. I hope in person after the COVID restrictions, and also would like to welcome you in Istanbul as well. Thank you very much.
Thank you very much.
Thank you, Aydan.
Yes, I felt a bit sorry that I have been sort of responsible for a breach of of the rule whereby ladies go first, but I'm sure that there will be another opportunity to make up for that, and maybe that will be in Bologna. I will be delighted to have the two of you, and perhaps give the chair to Anna, and see the two of you, and maybe even Antolin, who knows, next year, God willing, we'll be meeting in person. Thank you very much. Thank you.
Thank you very much. The same for Paris or Kyiv. So we will have a world tour of arbitration.
With great pleasure.
Thank you very much, and hope to see you soon.
Thank you very much.
Bye.
Thank you. Bye.